Hello there. This video aims to explain the primary facts and the holdings in the Australian copyright case, the University of New South Wales v Moorhouse, 1975, with respect to authorization liability. This case holds significance as it has been said that it defines one of the boundaries of authorization liability in copyright, and has been used as precedent in many cases involving authorization. Before we can begin looking at the case, we need to know what authorization liability is. So basically, it's where an intermediary, a person who acts as a link, has authorized the infringement of copyright and is therefore liable themselves. Simple enough, right? So what happened in the Moorhouse case? Well, the University of New South Wales allowed unsupervised access to coin-operated photocopiers adjacent to its library, and this caused issues. Moorhouse was the author of a published book, which was on display in the library on open shelves, and which was subject to copyright. An attendee of the library used the library's photocopying facilities to photocopy 10 or so pages of Moorhouse's book, without the consent of Moorhouse. This constituted copyright infringement. The photocopiers were not subject to any supervision or control of what books were photocopied. Notices were placed near the machines, and guides were issued regarding proper use. So that's a rundown of the facts of the case. Now let's look at the holdings of the case. What legal determination did the court make based on the facts? Ultimately, the High Court ruled that the University of New South Wales was liable for authorising copyright infringement. This means that the court found that the university had authorised the act of photocopying the book, and that the photocopying constituted copyright infringement. So what is authorisation? Justice Gibbs stated that it had been judicially held that the word authorise holds its ordinary dictionary meaning, that is to sanction, approve, or permit. But he also said that authorisation requires a mental element, and cannot be inferred if a person doesn't know or suspect that infringement may occur. Justice Jacobs, on the other hand, took a wider approach, recognising that the university had invited users to use the photocopying facilities as they see fit. The case's third judge agreed with Gibbs. The court also stated that a person cannot authorise an infringement without first having the power to prevent it. The court reasoned that the university was the owner and controller of the library and the photocopying machines, and it was reasonable to know or suspect that infringement may occur. Therefore, they had the power to prevent infringements. The court stated that where the university has control over the means of infringement, the photocopiers, and makes the photocopiers available for other people to use, knowing that they may use the machine to commit an infringement, authorization of that infringement occurs when no reasonable steps are taken to prevent it. So, at this point we know that the university has authorized copyright infringement, unless it has taken reasonable steps to prevent infringements. Given the ruling of the case, it's pretty clear that they didn't. It was found that the university had employed library attendants, but that these attendants did not supervise the materials photocopied, and only had duties regarding the maintenance of the machines. Additionally, the notices placed near the machines were found to have contained irrelevant sections of the Copyright Act, and were ultimately misleading. It was also noted that the relevant sections of the library guides issued were likely to be ignored by many of the users. It was noted that if notices had been clearly worded, accurate, and placed in a position that would not be overlooked, this would have supported a case that reasonable steps were taken. Alternatively, if the university had employed supervisors for the use of the machines, this too would have been reasonable preventative steps. So, we were right. Although the court recognised that the university had taken some action, the action taken was still found to be insufficient to prevent copyright infringement, meaning the university had authorised the infringement. So that's the facts and the holdings of the University of New South Wales v Moorhouse with respect to authorisation liability. Oh, and as an added bonus, if you're wondering what this has to do with internet law, take a look at the double INET case regarding internet users downloading copyright content.